gon' talk about it. Let's talk about it. Get in here, we in here tonight. So get in here, we in here to vibe.
Good afternoon. Let me know if you can hear me. Let me know if you can hear my voice. Good afternoon. Good afternoon. Welcome to the Talk About It with the Amore Show. Let me know if you can hear my voice before we move on. I know it's early, but I want to go ahead and get this out the way. And then possibly after I take a midday nap, I'll come back later and you know, we'll talk about something different. But let me know if you can hear me right quick. Oh, yes, we can hear you. Okay, thank you, Adisa Numi. Appreciate you. Hey, you guys, please hit that thumbs up button for your girl. Please hit that thumbs up button. Thank you for my first super chat, love 1980. I do have a goal set for $25 super chats. That is $100. And I also have my coffee link set above. If you guys want to bless me with a coffee, that would be greatly appreciated as well. Y'all, the state has responded to the defense. This does not mean that the appellate has responded yet, you guys. The appellate court has not responded, so we won't know if it's going to be approved or not. However, the state has responded. And baby, when I tell you they did not come to play. But anyway, we're going to go over it. It is very long. It's 18 pages. We're going to go over it. I may even let ChatGPT help me read some of it or whatever. And then I'm going to break it down and try to explain to you guys what basically it means. Okay. All right. So without further ado, please hit that thumbs up button and raise your hand if you've already familiar with the defense version. She said, Lord, my nerves, girl. And I have not read the whole thing, but I have read some of it. And I was just like, I had to stop. I said, let me just go live. Let me just go live. So with that being said, I have not read the entire 18 pages, but I read enough to know that they are not planned. They definitely do not want her to be released. Okay. So what I'm going to do, hold on one second. I am going to upload it in ChatGPT. Hold on. And this is the state's version. Raise your hand if you've already heard it, defense. If not, I will drop the link for you guys to go and hear the defense version. I kind of know the defense, so I can kind of tell you what the defense is saying versus what the state is saying, okay? They are painting two totally different pictures. I mean, that's normal though. She said, why people lying saying appellate sided with the lower court? Maybe that's some type of April Fool's joke because the state just turned their response in, okay? The state turned their response in, okay? Hold on one second, you guys. All right. So, hey, everybody, y'all come on in, hit that thumbs up button. I do have the 18-page state response to go over. Thanks for the young lady that got me this. I'm hearing I'm the first person with the paperwork, so I don't think anybody have it as of right now, but they may, shit. But for right now, I'm hearing that I am the first one that has this paperwork. So thanks a lot for thinking of me. Appreciate you. So we're going to get in this again. This is the state's response to the appellate court. Now, I read the defense response. The defense is basically saying my client does not need to be locked up because the information that the state is relying on is not valid. Okay, so they uploaded some video footage of witness number 3, her whereabouts, and also basically in a nutshell saying the information that the state received is not true. And also that they did not take into consideration that Holly had a restraining order and that Romika, the deceased, had been stalking and harassing her and threatening her for a while. And she did everything she could legally to stop it. And then she got pulled up on and blocked in on September the 8th is what the defense basically saying in a nutshell. And the state pushed back hard. I'm going to go ahead and let you guys know that. Again, I have not read the entire thing, but from what I have read thus far, the state is pushing back in a tremendous way. They're not buying it. They come in real hard. So we're going to go over it. Again, I am going to have ChatGPT read some of it for me because it's 18 pages, but I'm going to have them read some of it for me. Hold on. All right. Hold on. Let me just open it up right quick. Hell, I might just do it myself and just have them explain what's what. All right. So again, this is okay. Let me put it up here because they always say, you know what? I don't know how to watermark though. Y'all, I do not know how to watermark. They always say I never put up the paperwork. I'll just show you guys the paperwork, but I don't think I'm going to put it up because it's not watermarked and they're going to have to go get it themselves. So this is the paperwork. Yeah, no, I'm not going to put it up. But anyway, y'all see I got the paperwork. So you see I have it here. Boom, 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 boom. Oops, boom, 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 boom. So I got the paperwork here and yeah. So anyway, but I'm not going to put it up. Just trust me, okay? Just trust me. I know they always say she don't put up the paperwork. She's not liable. She's not credible because she doesn't put up the paperwork. Well, the paperwork is definitely here. All right. So anyway, of course, I'll put this up though. This is people of the state of Illinois, plaintiff and versus Cordasia Johnson, which we call her Holly here. Okay. We call her Holly. All right. So let me get into this document, y'all. So again, people of Illinois, this is a response to the defendant's appeal. Now, and it's from the order denying the pretrial release. All right. So this is the part I'm gonna let ChatGPT read for me. Hold on, because this is I don't have to read all that. Give me a second. I'll read the good part. I'll read the juicy part. I'll let ChatGPT read this part. Give me a second. All right, you guys. All right. Where is my ChatGPT? Oh, it's right here. Hold on. All right, here we go. Okay, hold on. Why is it not? Give me a second. Hold on 1 second. It's not giving me the option to read it aloud. I wonder why. Oh, I gotta break. It told me to break it out. Hold on. Give me a second, y'all. Well, your girl might just be reading it herself. Give me a second. I'm sorry. Hold on, y'all. Hold on. Give me a second. Work with your girl. Work with your girl. I'm trying to upload this thing. Trying to read this thing. All right. Why it's doing that? Why it's thinking or whatever. I'm going to go ahead and get into it. All right. So basically it says that the people of the state of Illinois, the attorney in this case is actually a female, right? And I actually thought that it was a male, but it's not. It's Aline O'Neill Burks. Okay. She's the Cook County State's attorney. All right. She responded to the defendant's appeal under Illinois Supreme Court rule as follows. All right. Am I loud enough? Can y'all hear me? Am I loud enough? The defendant, which is Holly, stands charged with 6 counts of first-degree murder. 6 counts, not 6 charges. 6 counts of first-degree murder, okay? And then it lists the statute for those counts. And then it says defendant was arrested on December the 3rd of 2025, and the people filed a verified petition for pre-trial detention hearing based on the safety threat that defendants poses to the community. A hearing was held on December the 4th, 2025, after which the court granted the people's petition, which means the court agreed with the state to keep her held in detention. The defendant now appeals from the court order and the subsequent denial of her release. Okay? I'm sure that's what that means, pretrial release. Let me get back to it. A motion for release. In support, the defendant relies on her memorandum in support of Illinois Supreme Court rule appeal. When the people seek to detain a defendant before trial, the Pretrial Fairness Act, which is the PFA, requires that they file a verified petition seeking detention, after which a hearing is held. That people must show by clear and convincing evidence that 1, the proof is evident or the presumption is great, that the defendant committed a qualifying offense, that she poses a real and present threat to the safety of a person or persons in the community. Based on that specific articulable facts of this case, and that no conditions or combinations of conditions can mitigate the threat she presents or prevent her willful flight from prosecution, right? Meaning that she might try to run away or whatever, right? The people's burden is not proof beyond a reasonable doubt. So when they say the people's burden is not proof beyond a reasonable doubt, so in court, in a trial, you have to prove beyond a reasonable doubt that this person did this or that. In the appellate court or even at the detention hearing, you do not have to prove beyond a reasonable doubt. So that's why the state wrote that here. The people's burden is not proof beyond a reasonable doubt. And then it quoted the same case study that Attorney Williams uploaded, People versus Williams, right? So the people's burden is not proof beyond a reasonable doubt. When parties proceed solely by proffer at a detention hearing, as occurred here, the standard of review is de novo, People versus Morgan. So what the state is saying is that they relied solely on the proffer, and the proffer is a summary of what the witnesses has shared, okay? So because they don't have any, video evidence of the incident itself, the shooting, pow, right? So they rely solely on the proffer, which is consistent of a summary of the witness statements, all right? So defendant first argues that the people failed to prove by clear and convincing evidence that she committed the offense of first-degree murder because she acted in self-defense. This claim fails at the outset because the people are not required under the PFA to disprove affirmative defense, such as a claim of self-defense at pretrial detention. So again, and this is important actually, because I heard a lot of people saying the judge said it wasn't self-defense. It wasn't self-defense. No, the judge did not say it was not self-defense. And even in the pretrial detention, you don't prove whether it's self-defense there or not. That's not where self-defense would be proven or proven against. Okay, proven for or proven against. All right. That's not where you do it at in pretrial. So right here it says, under the PFA, the people are not required to disprove affirmative defense, such as the claim of self-defense at pretrial detention. And then another statute. The court wrote in Illinois, the question whether a defendant use of force was ultimately justified is a matter resolved at trial, not pretrial. Okay, so this is not where Ari will argue, but it was self-defense. It was not murder. It was self-defense. The people, the state of Illinois is saying this is not where she do this at. She has to do this at trial. Has nothing to do with detention, pretrial detention. So, for it is the responsibility of the trier of facts to fairly resolve conflicts in the testimony, to weigh the evidence, and to draw reasonable inference from basic facts to ultimate facts. And it says, citation, a claim of justification is, of course, relevant at pretrial release hearing, but merely because a defendant might raise a defense at trial is not dispositive of pretrial release concerns. So basically here is saying, just because you might say that it was self-defense at trial, that has nothing to do with pretrial release. Like, that's none of our concern right now, whether or not you raise that, because just because you raise it doesn't mean that it's going to be proven. So the state is saying pretrial has nothing to do with whether or not you raise that concern or not, or excuse me, raise that defense or not. All right. So then it goes on to say this rationale is especially applicable here, where defendant claims of self-defense depends almost exclusively on videotaped evidence, none of which the defendant included in the record of appeal. An appellate is responsible for presenting a sufficiently complete record, and any doubts arising from an incomplete record must be resolved against her. Okay, so basically it sounds like they're saying there is no video evidence to show that it was self-defense. Okay, if it was self-defense and if they had video evidence that it was self-defense, the state is saying they should have uploaded it already. Okay, and that because they didn't, that's against her. That's against the attorney, not against them. So that's what they're saying. Regardless, the claim of self-defense has no merit. That's what the state is saying. It has no merit. Defendant and the victim had a history of disputes. In July 2025, the defendant secured a default stalking no contact order against the victim, which the court issued after the victim failed to appear for court hearing. The victim appeared with the defendant in a Zoom call in June 2025, but they never met in person until the date of the shooting. The victim was never served with those court orders. The defendant said the victim made threats against her via defendant's family member. However, the alleged threats occurred months earlier. Okay, so right here, the state is trying to discount the threats. They're trying to downplay it and say, because the threats happened, I think it was 6 or so months before this incident, that they don't count. Now, I don't think that that's going to hold water simply because it just took that long for them to go to court. Okay. But I don't think that's going to hold water. However, that's what the state is saying. The people proffered evidence at defense hearing that the defendant and the victim both had a child with witness number one, which is Carlos, who was in a relationship with the defendant in 2025. On the morning of September the 8th of 2025, witness one drove his black Mercedes SUV to 20 West Cermak, which is near a school, and double parked the SUV 2 lengths in front of the defendant's black Chevy Cruze. The defendant moved her child from witness one's SUV to her Chevy. At about 9 a.m., the victim, Romika, dropped her child off at school, then drove towards the location where the defendant and witness one had parked. She parked behind and to the east of witness one's Mercedes and got out of her car. Contrary to the defendant's assertions, the victim's car was in front of the defendant's car and never blocked in. That is not true. Wait a minute, hold on. It said, contrary to defendant's assertion, the victim's car was in front of defendant's car and never blocked in, meaning that defendant was free to leave at any time during the encounter. So basically right here, they're saying Romika's car was in front of Holly's car and never blocked in, meaning that the defendant was free to leave at any time during the encounter. Well, we all know that it was not in front of her car. We do know that. We've seen photos. I'm not sure what photos that they are referring to, but it was definitely to the side of her car, not in front of her car. At the scene, defendant and the victim stood in the street arguing by the open door of the victim's Kia. Witness one was standing between the two women with his arms extended. It appeared that the defendant and the victim were arguing about Carlos. The victim, Romika, was not acting aggressively, but the defendant was aggressive. So trying to say Romika wasn't aggressive, but Holly was. Defendant was charging the victim and trying to provoke her. Defendant advanced toward the victim, but witness one, Carlos, held her back. Witness one pushed Holly away from the victim, who was unarmed and stood stationary with her arms crossed against her chest. Now, y'all know we don't believe none of that bullshit, but let's continue. The victim walked to the driver's door of her Kia. Carlos struck her repeatedly by closing the Kia car door on her. Witness 3 called 911 to report that Carlos was striking Romika with the car door. The victim then got into her car. Defendant approached the victim's car and threatened her, at which point the victim got out of her car. Carlos approached the victim from behind and put her in a chokehold with his right arm while striking her with his left arm. Defendant Holly approached the victim and appeared to be trying to provoke her. However, the women were only arguing and did not engage in a physical fight. The victim, who was still unarmed, had her hands flailing in the air and trying to break free from Carlos's grasp. Holly threatened to shoot Romika, and Carlos warned Romika that Holly had a gun. Holly kept repeating that she was licensed to carry. Holly went to her car and retrieved a handgun. Romika freed herself from Carlos' grasp and stepped away from Holly. Holly pointed her handgun at Romika, walked toward her, and fired multiple times at her with a pause between the first shot and subsequent shots. Witness 4, this is the cross guard, was walking away when he heard one shot, followed by 2 gunshots. He looked back and saw Holly holding a handgun. The victim, Romika, was shot multiple times in the face and leg and collapsed. Carlos and defendant fist bump. Witness 3 then called 911 a second time, this time to report that the defendant shot the victim. Police arrived and transported the victim to the hospital, where she was pronounced DEAD. Witness 3 identified defendant to the police as the shooter. Defendant admitted shooting the victim and was detained. She told police that it was the first time she saw the victim in person and said she shot in self-defense. She had a valid FOID card and concealed carry license. Police recovered a loaded 9mm handgun from her car. The court granted the people's petition to detain Holly, finding that the people showed that the proof is evidence and the presumption great that a first-degree murder case occurred because disinterested witnesses said the victim was unarmed and stood with her arms crossed. Witness 1, Carlos, put the victim in a chokehold. Defendant threatened to shoot the victim and said she had a gun. Defendants went to her car and retrieved a gun. The victim broke away from the witness 1's chokehold and moved several steps away. Defendant shot the victim, pausing between her first shot and subsequent shots. With regard to the defendant's claim of self-defense, the court observed that the victim was never seen with the weapon and never struck defendant. There was no evidence of injury to the defendant and that it was just happenstance, not stalking, that the victim and the defendant met that morning. Now, come on. Oh, wow. So basically they saying it's just a coincidence that they met that morning. It was not stalking or anything like that. She just so happened to see them. The court found that the peoples demonstrated that defendant presented a safety threat. Hold on. The courts found that the people demonstrated that the defendant presented a safety threat because she committed the offense in public at a busy intersection near a school, undeterred by the presence of children, witnesses, and her own child. The court said Holly is absolutely a threat to the community and to these witnesses. The court condemned the kill shots and the celebration that took place after the shots and said, this defendant has proven that she will exert deadly force over verbal arguments. With regards to the possible imposition of limiting conditions of release, the court concluded that neither electronic monitoring nor house confinement would deter defendants from harming the the witnesses or anyone else she encounters, that she would perceive a threat based on her own words. The courts observed that defendant had received training in order to gain her concealed carry license, but she violated the rule she was taught, demonstrating that she will not comply with the conditions of release. The court's ruling should be upheld. A person commits first-degree murder if, in causing a death, she intends to kill or cause great bodily harm to the victim, knowing that conduct will result in death, or knowing that conduct creates a strong probability of death or great bodily harm. Here, the defendant's intent was made clear by the fact that she shot the unarmed victim point blank, pausing after the first shot to fire 2 more. The court said defendant made sure that the shots were fatal. It says, and then it gave another case law. And then it says, even if the people were statutorily obliged to disapprove a claim of self-defense, okay, meaning that if the state fails to disapprove the claim of self-defense at trial, it would fail because the evidence does not support it. Defendant's primarily challenge is to credibility of witness 3. Okay, it says defendant's primary challenge is to the credibility of witness 3, who saw defendant and the victim arguing, saw witness 1 striking the victim by closing her car door on her, saw defendant approach the victim and threaten her after the victim had returned to her car, heard the defendant threaten to shoot the victim, saw the defendant retrieve a handgun from her car, saw the victim escape from witness number 1 grasp and step away, saw the victim walk toward the victim and shoot her, and call 911 twice to report the crime as it was taking place. The defendant argues that witness 3 could not have heard what the parties to the offense were saying because she was wearing headphones. However, witness 3 was still wearing headphones when she spoke with police after the shooting, showing that she could hear through her headphones and that she told the police that she could hear everything. Other witnesses heard the same thing that witness 3 did. The state is, anyway. The defendant also argues that witness 3, who was riding a bus when she first saw defendant, could not have seen the shooting from her vantage point once she got off the bus. Since this argument is premised on videotape from the scene, which the defendant did not include in the record on appeal, any doubts must be revolved against her. Furthermore, the trial court watched the videotape and disagreed with the defendant's argument that witness 3 could not have seen the crime scene after getting off the bus. The defendant argument also fails because witness 3 called 911 twice to contemporaneously report that she was seeing, and witness 3's account is supported by and does not contradict accounts given by other witnesses. The defendant further based her self-defense arguments on her proffered evidence that Carlos would testify that the victim ran up on the defendant and swung on her. The defendant told the victim to leave her alone. No other witness saw that take place. Moreover, the trial count characterized witness 1, which is Carlos, as the only person who was not an independent witness because he has motive, interest, and bias to testify in a certain way. The trial court said it gave greater weight to the testimony of witness 2 through 5. Finally, defendants argued that one of the witness 3's calls to 911 suggests that the victim was the aggressor in the scenario. The people disagreed, pointing out that it is unclear as to who she's talking about at various points about who's the aggressor, because the phone call itself is unclear. Moreover, as stated, none of the witnesses except for witness 1, which is Carlos, suggest that the victim acted aggressively toward the defendant. There is accordingly no merits to defendant's claim of self-defense, and the trial court properly found that there was clear and convincing evidence of a detainable offense. Then they do another case law. And then it says, okay, next, the defendant contends that the people failed to show clear and convincing evidence that she poses a safety threat. To the contrary, the people's garnered specific articulable facts demonstrating that the defendant poses a safety threat to a person or persons in the community, including anyone who confronts her. Her claim that she shot the victim in self-defense is nullified by the combined accounts of 4 total disinterested witnesses, none of whom saw the defendant threatened by the unarmed victim. The defendant did not just shoot the victim once, but 3 times. Clearly a matter of intent and choice. Moreover, the shooting took place in broad daylight at the start of the school and workday, when there was adults and children all about, as evidenced by the number of witnesses who saw the shooting. The trial court properly concluded This defendant has proven that she will exert deadly violence over verbal arguments. Anyone who is capable of that and has the ability and the willingness to act on it is absolutely a threat to the community and to these witnesses. The statutory factors supporting the trial court denial of pretrial release include that defendant committed a crime of violence. She poses a threat to the community at large and to the witnesses in this case, all of whom defendant named in a pleading, and she was in a possession of a gun. In addition, the nature and circumstances of defendant's offenses is that she shot the unarmed victim multiple times with adults and children in the vicinity, and the evidence of her guilt is overwhelming. The foregoing statutory factors firmly support the trial court's detention ruling. The case is comparable to Peoples versus Batty, where during an argument that took place outside of an apartment complex, the defendant displayed his gun as a threat to the victim. The defendant had prior issues with the victim. A witness told the victim to calm down, but the defendant shot the victim. A BB gun was found underneath the victim after he was shot, and the defendant claimed that the victim pointed a gun at him first. But witnesses said the victim never had the gun in his hand, made any threats, or pointed a gun at anyone. Even though the defendant had no criminal record and lived with his parents, the court found that he posed a danger to the victims and to the community because he possessed and had access to a firearm. The weapon was a modified automatic firearm. The defendant admitted shooting the victim, and the defendant opened fire in a public area at an apartment complex. So to this case, even though the defendant has a limited criminal record, she admitted shooting the unarmed victim, who was simply arguing with her and never physically threatened her. Indeed, this case is even more egregious than Batty, because here the victim was backing away from the defendant when she was shot. Oh, Jesus, the lies, the lies. Okay, it says, see also Peoples versus Clark. Court rejected claims of self-defense and found that the defendant posed safety threats where he shot an unarmed man across public streets after two exchanged words. A defendant's commission of a violent crime can outweigh a defendant's limited criminal record. And then it says another one, People versus Manzana. Defendants who stabbed victim was safety threat despite limited criminal record. People versus Chapman. Defendant charged with first-degree murder and home invasion posed safety threat despite no criminal record. So basically, they just put the case laws down there saying this person didn't have no criminal record, but they committed murder. This person didn't have no criminal record, but they committed murder, and that they had to be detained as well. So finally, defendant argues that she only shot after the victim went to her car, but came back to attack. To the contrary, the evidence showed that the victim got into her car after witness one repeatedly struck her with her own car door, then got out of her car again only after the defendant approached and threatened her. If the defendant truly felt threatened, she could have used the phone in her car to call the police or could have simply driven away. However, she chose not to do that. The trial court therefore properly concluded that the defendant posed a safety threat. Next, defendant argues that the people failed to show by clear and convincing evidence that there are no conditions that can mitigate her real and present safety threat. In determining whether conditions of pretrial release can reasonably ensure the community's safety and likelihood that the defendant will comply, courts consider substantially the same factors considering in determining whether a defendant poses a real and present threat under this statute. See Peoples versus Saucedo, noting a similarity in applicable factors. Trial courts are endowed with consideration discretion, where call upon to weigh and balance a multitude of factors and arrive at a decision that promotes not only principle of fundamental fairness, but sensible and effective judicial administration. People versus Reed, quoting Cesarnica versus Uno Vinco. The statutory factors discuss milligant. I'm sorry, y'all. I'm fucking up these words. The statutory factors discuss mitigate against any conclusion that any combination or conditions can mitigate. Why I say mitigate? Mitigate defendant's safety threat. Defendants argue for release on electronic home monitoring, but the trial court concluded that it would not mitigate her real and present threat to the community's safety based on the nature of the defense where multiple shots were fired. Based on the fact that EHM, electronic home monitoring, cannot respond in real time to protect someone who is reaching to a vital situation. The court was unwilling to give electronic home monitoring to someone who thinks that a verbal argument justifies murder. And not just someone who has that belief, but someone who acted with lethal consequences on that belief. In People versus Roman, the court said dangerousness and conditions of release are two sides of the same coin. The nature and severity of the threats necessarily determine the nature and severity of the conditions that could or could not mitigate the threat. Defendant argues, however, that the nature and circumstances of an offense is just one factor a court should consider in determining whether conditions of release apply. The decision in People versus Graham is on point. In Graham, the defendant and the victim had a history of bad blood. While in line at a restaurant, the victim backhanded the defendant, who left and returned a few seconds later with a handgun. The victim ran into a parking lot where the defendant pursued and shot him. The victim fell to the ground. The defendant walked up and shot him again at least once, then fled. The victim fell to the ground. I'm sorry, not fled. Oh yeah, fell to the ground. The defendant walked up and shot him again at least one time, then fled. The defendant, who had a concealed carry license, argued that he should be released with conditions because he had disabilities, was employed, and had no adult criminal history or history of violating the court order. The reviewing court disagreed, writing that this is such a case where the defendant charged conduct reflects such a departure from the basic expectation of civil society that it casts doubt on his ability to comply with the trial court order or societal norms regarding the safety of others despite his lack of criminal history. But, let me go to this case right quick. Even though I'm going to go over this whole thing, this guy ended up getting free off of self-defense, though. People versus Graham. That's the one that the guy was beating a woman in the restaurant. And the guy, and she told her son to go out to the car. And y'all know what I'm talking about? Go out to the car and get the gun and shoot him. And the guy, the victim ran out to the parking lot, and the son ran behind him and shot him. But anyway, he ended up getting found not guilty. I mean, it didn't even go to court. It didn't go to court. But anyway, let me finish. I'm sorry. So anyway, the reviewing courts disagree, writing that this is such a case where the defendant charged conduct reflects such a departure from the basic expectation of society, and that it casts doubt on his ability to comply with the trial court's order of societal norms regarding the safety of others despite his lack of criminal history. And then is quoting Romain. The Graham court stressed that apart from the bare elements of the charged offenses, where the facts that the defendant shot in a crowded area, chased the fleeing victim, and shot him when he was already on the ground. Similarly, Similarly, in this case, defendants outsized reactions to the victim's argument with her. Let me take some water. Child, hold on. All right, let's start over. Similarly, I can't even say the fucking word. Similarly, I can't even say the word, y'all. If I don't think about it, I can say it. But anyway, I'm thinking about it, so I can't say it. But anyway, in this case, defendant outsized reactions to the victim's argument with her. Her taking advantage of Carlos pinning the victim to retrieve the gun, shooting the unarmed victim multiple times, and committing the offense in a public area. All amounts to the sort of egregious offense precluding release with conditions. So basically right here is saying, in this case versus, I guess, this case, the Graham case, it says defendants outsized reactions to the victim's argument with her. So basically saying Holly took advantage because Carlos was holding Romika, allowing her a chance to go retrieve her gun, is what this is saying. So anyway, and it says, defendant cites People versus Miller for the proportions that courts have held that first-degree murder charges are insufficient to sustain pretrial detention. The difference is that the defendant in Miller punched the victim once with a bare fist. In this case, defendant shot the unarmed victim point blank 3 times. So what they're trying to say here is they're trying to say in this People versus Miller, Miller punched the victim. They're trying to say Romika did not hit Holly. That's what they're trying to say here. Defendant next cites People versus Atterbury. For the proportion that pretrial release should not be ruled out based on the perception that conditions of release are loosely monitored. The relevant question on review, however, is not whether the court believed the electronic home monitoring is loosely monitored, but whether the trial court considered the adequacy of the electronic home monitoring, specifically with regards of the defendants before it. Peoples versus Kuhn. The Kuhn court pointed out that the code requires a court to access the adequacy of pretrial release conditions. Here, the court discussed defendant's specific characteristics in assessing her safety threat, including her character lack of criminal background, order of protection, and work background. In light of the facts of this case, however, the court concluded that the defendant's contempt for social norms, societal norms, render it unlikely that she would demonstrate the kind of buy-in required to make electronic home monitoring effective. So they're basically saying, yeah, she's not a candidate for electronic home monitoring. That's what they're trying to say here, that Holly is not a candidate. Lastly, we're on page 15, y'all. I cannot believe I just did all this damn reading. Lastly, the defendant argues that the trial court failed to consider alternatives to the electronic home monitoring. Prior to filing her memorandum in support of Illinois Supreme Court R 604 appeal, however, defendant never suggests any conditions alternative to electronic home monitoring. Furthermore, while it is the people's burden to show that no conditions can mitigate the defendant's safety threat, the peoples are not bound to address every conceivable condition. So right here, the state is saying that the defendant, meaning Ari, did not offer any alternative conditions to the electronic home monitoring. So they saying you ain't gave us no other way. So like you ain't give us an alternative. Okay, so that's on you. Basically, they saying it's not up to the people, it's not the burden of the people to show no conditions can mitigate the defense safety. The people are not bound to address every conceivable conditions, meaning that Ari have to come up with what can and cannot work other than electronic home monitoring. Okay, so they saying you ain't gave us no alternative, so that's on you. People versus Michalotis. All right, anyway. Furthermore, the record shows that the court did not consider alternatives to electronic monitoring. The court recognized that the most powerful tool available to it to mitigate defendants' dangerousness was electronic monitoring. So now they're saying electronic monitoring is the most powerful tool out there, right? So if the court found that the most powerful tool available was insufficient to mitigate defendant's dangerousness, then it follows that less powerful tool, i.e. alternative to electronic monitoring, would be insufficient. So basically they saying, well, if electronic monitoring ain't good enough, then ain't nothing good enough. Defendant argument should therefore be rejected because the circuit court knows the law, including conditions of release and less restrictive alternatives to detention, and in weighing the proffered facts against those less restrictive conditions, the circuit court engaged in a consummate exercise of discretion that it is entitled to deference of appeal. People versus Carpenter. And then it says, see Peoples versus Drummond. For these reasons, the trial court grant of the People's petition for detention hearing should be upheld. So they are asking the appellate court to uphold their request to keep Holly detained. Okay. So now let's go over this because I found it to be strong but weak. Strong but weak. And we're going to go over it. Okay. Why do I say strong but weak? There was a lot of good strong points they put in there. However, I want to go back to the part where they said the defendant, meaning Ari Williams, did not upload a video or did not turn in a video. I want to get back to that right quick because I don't want that to slip my mind. It's saying that she did not give a video showing that witness number 3 was not right here. All right, so let's highlight this right quick because I'm not sure if she did. I hope that she did. I have not even spoke to anyone about this, but Lord, Father God, I hope that she did. But right here it says, okay, hold on. Let's get to it. Furthermore, no, not right here. I'm sorry. Defendant argues witness was around a bus when she first saw it. Okay. So right here, it said the defendant, meaning Ari, the attorney. I'm sorry, y'all. I got to get my lines. It says defendant argues that witness number 3, who was riding the bus when she first saw the defendant, could not have seen the shooting from her vantage point once she got off the bus. Okay. And it also says, since this argument is premised on video from that scene, okay, which defendant did not include in the record of appeal, it says any doubts must be resolved against her. So it's saying that they did not submit a video. Right here, defendant also argues that witness number 3 was riding a bus when she saw, oh, hold on, let me make sure I got y'all in the right place with me. Do I? Okay, I do. All right, so it says, defendant also argued that witness number 3, who was riding a bus when she first saw the defendant, could not have seen the shooting from her vantage point once she got off the bus. Since this argument is premised on videotape from the scene, which the defendant did not include in the record of appeal, any doubts must be resolved against her. What? Why in the world would she not include that? Yeah, I know. I'm sorry. Hold on, y'all. Give me a second. Oh, I'm sorry, y'all. I was not reading the comments. I got a lot of people texting me saying, Amora, stop showing the documents. But y'all, I already showed them. I'm sorry. Child, I wasn't reading the comments. I'm so sorry. So apparently the state uploaded this before before all the evidence was uploaded, which is dumb. That's dumb as fuck. So anyway, so the video and everything is included now. It wasn't included in its original, but they now have it. So I'm going to assume that there's going to be a follow-up from the defense attorney, because there was submitted. Okay, the video footage was submitted. It just wasn't submitted originally, but they asked for it to be submitted in its entirety, and it was submitted in its entirety. So I'm assuming the state wrote this up before the defense submitted all of their evidence. Okay. So that's one thing I wanted to go over. The next thing I want to go over is a lot of this information is from the proffer, right? Basically saying, I'm gonna take this down because I didn't even watermark it, y'all. I don't even know how to watermark, to be honest with you. But anyway, a lot of this is basically saying what witness number 3 said. What witness number 3 say. A lot of this is based on the witness statements. Heavily witness number 3. Heavily witness number 3. Okay. So if Ari can discredit witness number 3, the state is going to be in a lot of trouble. However, right now, it comes down to whether the appellate court thinks that the state did their job or not even the state, but the circuit court did their job in trying to find any condition of release, meaning that did they weigh on everything, right? But they pushed back on her, right? They pushed back on Ari and saying, okay, Ari, you're saying that the electronic home monitoring, right, is not the only conditions, that there's others, but you didn't offer any other condition. And that's on page, I think, 15. So it's saying basically you have to let us know what you're thinking. But then they come back and say, however, the electronic home monitoring is the strongest thing, and the court already agreed with us that electronic home monitoring won't even work. So if that's the strongest, most powerful tool they have into keeping tabs on a defendant, I guess you can call him a defendant. Then if that doesn't work, then nothing can work, is basically what they're saying. However, they're saying, but you didn't even offer anything else. So I'm sure Attorney Ari is going to reply to that as well. Now, another thing they stated, that the car was not blocked in, that it was actually parked in front of, Holly's car. Let's get to that one. And said that it was not blocked in. Right here, it says, contrary to defendant's assertion, the victim's car was in front of Holly's car and never blocked in. And it said it was in front of it and never blocked in. And it said the defendant was free to leave at time during the encounter. Now, from what I heard that they have video footage that proves that the car was blocked in. So I'm looking for Ari to submit that. I want to see something on that. Okay. And we all know that she was not parked in front of Holly's car. I find that to be a lot of stretch from the state. Okay. And then it goes on down here. Of course, it says, and a lot of this stuff is based on now witnesses, right? That Romika had her arms folded while Holly was just doing the most, right? Now, we all know that over here that that's not true. Now, we know other people may say other things, but we just know based off of Romika's behavior that shit ain't true. It ain't no damn way she had her arms folded and Holly was popping smoke and she had her arms folded and didn't do nothing. We all know that. I believe that Romika's family knows that. Her cousins and sisters, they all know that, okay? I believe that smart people in this case also know that as well. Ain't no way she's standing there with her arms folded when she's the one that pulled up with the smoke in the first place. And then I noticed that they also, even though the courts threw it out, right, for detention purposes, I noticed that the state put the fist bump back in there. And I'm assuming they did that because they're definitely trying to make their case strong, okay? So with this right here, I know, or I feel that Ari will be given a response to this because there's so many, wait a minute, hold up. You know what I'm saying? In this paperwork, okay? But it seems like they put everything that they could. To me, I feel like the state threw the kitchen sink at this appeal. But this tells me this is as strong as it gets. In my opinion, this is as strong as it gets. I don't see the state being able to prove their case based on what they have uploaded, because this seems like they threw the kitchen sink, right? But this is as strong as it gets, and it's not that strong. It's basically saying the state is relying heavily, like 98%, on the witnesses. That's what their case is built on, the witnesses. The witness identified this. The witness identified that. The witness identified this. So it is weighed heavily on the witnesses. Okay, now I did a what's strong and what's weak about this this response. Okay, so let's get into what's strong and what's weak about this response. Give me a second. And you know what? Hold on. I'm telling it to take out the defense. Right now, we're going to focus solely on the state. All right. Now, I did do a comparison of the two, but right now we're just going to focus on the state, okay? So now, what did the state attorney do well in this write-up, all right? So, it looks like they leaned hard on the law, right? They kept saying, this is not trial. We do not have to prove everything right now. And that is true, okay? That is true. In the detention stage, it doesn't require proof beyond a reasonable doubt like a trial does, right? So it's very minimum because it's just for detention release. So they don't have to prove that it wasn't self-defense. They don't have to prove that it was an intentional murder, right? They just have to prove very minimal things, right? So they kept ringing in on that. This is not trial. We don't have to prove everything yet, okay? So they lowered the burden on themselves, all right? So they played it safe by arguing law more than the facts, all right? Meaning that they can have some shit wrong, and I believe that they do, but they're sticking to the law in this response. Another thing that they did very well, they framed Holly as a danger to the community. They said it was a public setting. She fired multiple shots and it was near a school with little kids. Even her child was there and could have been put in harm's way. Why does this matter? Because judges care more about public safety first, all right? So they're trying to make the judge feel like releasing her is very risky, okay? Now, another thing that they did that did well in this report, they repeated the same narrative over and over and over again throughout, right? The victim was unarmed. The defendant fired multiple shots. Witness supports the same story. They're independent witnesses, okay? That repetition is done for persuasion, okay? People, when you tend you hear people, even content creators, when they keep saying shit over and over and over and over and over again, they are trying to persuade an audience. And that's what the state is trying to do here. Persuade the judges. The victim was unarmed. She didn't have a weapon. The defendant fired multiple shots. And all the witnesses are independents, but they support each other's story. All right. So the state feels that if they drill that story, then it begins to stick. Okay. So another thing, they lean on the trial judge's decision. They did. The lower court already found this case credible. The lower court said that, we did right. The lower court agreed with us. So basically they're saying, don't second guess the trial judge. The trial judge then already agreed with us. The trial judge agreed that electronic monitoring won't work. The trial judge agreed that she is safety to the public. She is a threat to the public. The trial judge agreed that she is a threat to the witnesses. The trial judge agreed that, y'all know what I'm getting at, right? So basically, they're trying to throw that back up and say, don't go against the trial judge, all right? Now, let's talk about where the state is weak at, okay? Again, I said this already. The case depends heavily on one witness, and that is witness number 3. Witness number 3 is doing a lot of heavy lifting in this case. Witness number 3, the state's star witness, right? The case depends heavily on her, okay? However, this is where it's weak. It states that witness number 3 was on a bus, wearing headphones, didn't see everything from start to finish. That's a problem. Why? Because that is not considered a clean eyewitness. You cannot say you seen majority of the incident when your ass was on a bus, walking down the street, ducking behind a building, wearing headphones, got your child and stroller with you, on the phone with the popo. You can't say you seen, because the state says she's seen majority of everything. The state cannot rely on somebody that's seen everything when they are on videotape here, there, and everywhere. Okay? So that will weaken their case. Another thing, they downplayed the video, then tried to dismiss the video, saying defense didn't include it properly. However, the appellate court asked for the video. The appellate court said, upload everything. We want you to upload everything. So if the video didn't matter, the appellate court wouldn't have asked for it. And from my knowledge, Ari uploaded the video. So again, this is state response before they realized that video was uploaded. Okay? So that's going to, because they downplayed the video saying, oh, it wasn't included, the defense attorney, if it was such an important video, they would have included it. Well, they did. They did. All right. Another weakness in this report, they admitted there was a physical altercation. They said that it was a chokehold and struggling happening, right? So in a self-defense case, in a non-self-defense case, in a straight up execution type murder or whatever with intentional, like first-degree murder, it's not a chaotic scene. It's more deliberate. It's more, I'm trying to kill your ass, bang, bang, bang. But the fact that they already admitted that it was some struggling going on. She was being detained or restrained, trying to get her loose, trying to wiggle her loose, and things of that. That creates a chaotic scene. And a chaotic scene based on how fast things was going, then that's not intentional. If it's already chaotic, already, some physical activity going on, some struggling happened, some restraining, some pushing back, some getting in between, that creates a chaotic scene. Chaotic scene doesn't automatically equal an execution. Okay. An execution is more deliberate, more intentional. Okay. Chaotic scene is more reactive, right? More quick on your feet type thinking. All right. Another thing, they relied on she could have left. All right. She could have left. She could have driven off. This is a weak real world argument. Why is that? Because people don't act perfectly under stress. You don't pause and calculate exits in danger situations. All right. Seriously, like, oh, she could have left. She had her child there. She was blocked in. Romika pulled up on her. Her car was blocking her in, and there's video footage to prove that. Okay, I don't know why the state said it wasn't, but they're gonna find out today, I guess. But and her child was in the car, so she didn't have an easy exit plan. All right. So the courtroom logics, not real life logics. Okay. So she could have left. Yeah, sounds good. It briefs well, but no. That's weak. Another weak thing in their response is they use emotional language instead of just facts. All right. They use emotional language like she was shot execution style. And that was the kill shot to her face. And they celebrated with a fist bump. All right. That is persuasion, not neutral facts. Okay. And basically, when they start using emotional words, they're trying to influence, not just inform. And court sees that, all right? Another thing, they dismiss the self-defense too confidently, all right? Saying it has no merit this early in the case. They're saying, yep, no merit. It doesn't matter. It has no weight over here, all right? That's risky because self-defense is usually a jury question. If it's that clear, then why not let the jury decide whether or not it has any merit or not, right? So that's kind of weak, and that's things that judges will point out as well. Now, again, the state response is strong but weak, all right? Because it's shaky on facts. It's strong but weak. Now, how do they win? The state wins if the judge believed the witnesses. If the judge weigh more on the witnesses and actually believe these 4 witnesses that's giving their testimony, then the state wins. And when I say win, I don't mean like win the trial, but they win this appeal. But they lose if they start questioning, are those witnesses actually truthful? Did they really see this shit? Did they really see what they say they saw? So, to be honest with you, this depends on whether or not they believe the witnesses are credible or not. This is going to come down to the witnesses. If the witnesses are credible or not. So, Ari, if she is able to discredit these witnesses, then things are good, right? But if she's unable to discredit these witnesses, then there's trouble in the land. There's going to be trouble in the land. She has to discredit these witnesses because that's what it comes down to, the witnesses, because the state is relying heavily on witnesses. The witnesses. There's no video footage. Where there is some video footage, but not in regards to the crime itself. Okay. So let me see. Do I have anything else I want to talk about? Hold on, let me see. Oh, and if they okay, that's considered a witness too. If they feel that Carlos is too biased, right? And if they feel that Carlos is too biased, if they weigh heavily on Carlos is too biased, and that the other witnesses are credible, then yeah, I don't see a release anytime soon. Okay. She says, I'm not talking specifically about the case, I'm referring in general. What was your question? Do anybody have a question? Do anybody have a question? Even more than that, there was an active TPO. They just dismissed it like it was nothing. Oh, let's talk about that. Give me a second. Let me see what it said about that. Because they did dismiss it. They dismissed it like, oh, that's old. It doesn't matter. The threats was to her family, not directly to her. Let's see what they said about that. Ooh, it's saying a lot about this damn TPO, baby. Yeah, but the state is definitely trying to dismiss the TPO. Definitely. All right, so this is what it said about the TPO. All right, so what the state is trying to do with the TPO, they're basically using the TPO to say she wasn't in danger. She had legal protection already, so deadly force wasn't justified. However, and they, well, let me continue. They're trying to turn the TPO into proof that you had an option that you didn't need to shoot. Okay. All right. You had a TPO, but you didn't need it to shoot. So, what's strong about the TPO? It shows prior conflicts existed. The TPO proved there was history between the two ladies. That helps the state argument. This wasn't just random, it was ongoing conflict between the two girls. It suggests she had legal remedies. Courts already gave you protection. So the state angle is that you could have relied on the system instead of using force. All right. They're basically saying she had protection. Why did you escalate it? It can be used to argue intent depending on the spin the state used, right? If the state implies she knew the situation, however, she still engaged anyway, then that feeds into this was avoidable. You already knew that she was a danger, but you chose to argue with her. You was already afraid of her, but you argued with her, right? So if they spin it that way, right, that may help them out. However, where they're weak at is they just downgraded it, right? Trying to say a TPO is just a piece of paper, not protection in real time. This is the biggest weakness. A TPO doesn't physically stop someone. It doesn't prevent confrontation in the moment, okay? That piece of paper don't protect you in real life. And people know that. People know how many times we heard somebody just got a TPO. It was a young lady that literally just walked out of court being granted a TPO. I think a divorce and a TPO. And her husband followed her, or it was her ex-husband at that moment, and unalive her. I'm pretty sure y'all heard of that story, right? So a protection order doesn't really stop harm. Yeah, it documents the threats, right? It documents that it was needed, but it doesn't necessarily protect you in real life, okay? It just protects you legally, but not in real life. Now, and the TPO actually supports self-defense if it's flipped like this, all right? A TPO proved there was fear there. There was threats made. A judge already believed something was wrong, okay? And this helps the defense argument. She had reasons to feel like her life was in danger. All right. You can't say she wasn't in fear when she already went to court and a judge granted her that order by default. And within that order says that under the preponderance of evidence, this court finds that you are in fear for your safety and that of your 6-month-old son, Carson, at the time. All right. Now, again, it doesn't eliminate immediate danger. Even with the TPO, if someone approaches you aggressively, a situation can still escalate, and it can escalate quickly. The law still allows self-defense in that moment. Okay. A TPO don't mean you can't defend yourself when someone pops off. All right. Especially when they just approach you, block you in. Right. So the state assumes perfect decision making. They're basically saying she should have handled it differently. She should have just called 911. She should have got in her car and just left. Right. They're saying that she should have handled it perfectly. However, people react differently under stress. Situations escalate quickly. Expecting someone to stay calm in a chaotic moment is just not realistic. And the courts understand that. All right. So, and another where they're weak at, it says it ignores enforcement reality. The TPO violations happen all the time. Police aren't there instantly. So they're saying you could have called 911 when you saw her. Well, this is saying basically, or the defense, if they flip it this way, they can say dialing 911 doesn't save someone that's violating a TPO. Sometimes it takes the police a longer time to get there if it's not like a dire emergency. So even if she would have called and said 911, this person is violating the TPO, they're not supposed to be around me, but they're here, that does not necessarily means that she would have been saved or protected from the law, basically. Okay. So anyway, they're saying the protection is delayed, not immediate. All right. So by the time the police would have showed up, it could have already been too late for Holly. All right. So again, the state is using the TPO to say she had options. But at the same time, the TPO also proved that there was already a problem and fear from Romika, fear that Holly had against Romika. So depending on, how it's looked, it could help both sides. It could help the state that there was already back and forth between the two, or already conflict between the two, or it can help the defense. She already documented fear. She was in fear of her life. All right. So it goes both ways, but the prosecution is absolutely trying to dismiss the TPO. All right. Now, let me ask one more thing about what about all right. Now let's talk. Well, now we're going to talk about the threats. We talked a little bit about the TPO. We're going to talk about the threats themselves. The state tried to say that they were months ago, like, oh, that was just months ago, meaning that it wasn't an immediate threat, like right now, right? That's what they're trying to say. So, again, like I just said, the state is trying to argue that the danger was not immediate. So in self-defense, the key issue is usually imminent danger, not prior bad blood, right? So from a prosecutor's angle, which is the state saying the threats were months ago, it's their way of trying to shrink the fear factor and make it sound stale, old, isolate. Yeah, that was no longer a problem. She was fine. She was fine, or whatever, right? But I don't think so, because if that was the case, why the fuck did she stop, right? And why the fuck did she run up on her, right? But nevertheless, what's weak about that state argument that the threats were old and stale and outdated and isolated and, non-factor. Old threats do not become meaningless just because the time has passed. Okay? If the order was granted for 2 years, she's protected for those 2 years. It does not matter if it came from old threats. All right? She is under a stalking order for 2 years. It was just granted 3 months prior to this incident, right? So if the threats were serious enough that she sought a stalking no contact order, right? And the judge found a preponderance of evidence that even though she didn't show up in court, it was by default, but the judge found preponderance of evidence to grant her the max amount of time order, which was 2 years in the state of Illinois, then something was there, right? It was serious enough for the judge, right? So anyway, so which means that it can support the idea that the fear did not just come out of nowhere. There was true fear. The defense memo says she sought the order in December of 2024 and that numerous threats were alleged and that she believed that the deceased would follow through on those threats to end her life someday. All right. So the defense also ties those prior threats to what happened in September the 8th, arguing that when the deceased approached, blocked the car, and allegedly attacked her, those earlier threats that Romika made shaped how she interpreted that moment. All right. So with that being said, the state is right that months ago weakens the emotional force of the threats, but the state overreaches if it acts like older threats no longer matter at all. Prior threats can still matter because they explain why someone feels fear in that moment, especially if there was already a protection order in place and history from that protection order, i.e., prior patterns of harassment. All right. So the state wants the courts to treat those threats like old news, but old threats can still matter if they can help explain why she believed danger was real when the confrontation happened on September the 8th. So, yeah, they trying to downplay the threats, but I don't think that that's going to happen because from my knowledge, the threats were not just to her family members. The threats was also to her as well. And I do believe the state knows that. So I'm actually kind of surprised that the state is, basically downplaying it like it don't really mean shit. Okay. She said, you can definitely hear and see the crime scene from the train. I ride past there every morning. However, I do not believe witness number 3. She added on stuff and had on headphones. Yeah, Romika was stabbing Carlos and hitting him, stalking Holly constantly, and even said to Carlos that she'll go to New Orleans to get a spell put on him because she had some of his hair on video. Damn. She said, but you do know that Holly could have been in her vehicle and recorded Romika and have a good case. So why didn't she? Because it was not her first reaction to. Yeah, I can't answer why she didn't do that. I don't think that would have necessarily been the wisest idea. But, I kind of do want to answer you. Okay. So to my knowledge, right? Carlos had calmed down the situation, calmed it down, got Romika to calm down or whatever and get in her car. I don't think that, and I could be wrong, but I just don't think that Holly thought Romika would get back out her car. So if a situation has calmed down, if the baby father was able to talk Romika, if he was able to talk her down and to get in the car, girl, chill out, get in your car, right? And he was able to do that. And then Romika agreed, make that bitch leave. I ain't going nowhere until that bitch leave. She got to leave. I ain't going nowhere until she leave. And Carlos, okay. Let me move my car up. And she can go or whatever. And then you can talk or whatever, right? Let's just say that happened. I don't know. Let's just say it did. So he thinking everything is calm. That, she thinking, Holly thinking everything calm. She thinking everything calm. She waiting for him to move his car up. They live an hour from each other. She waiting for him to come back so they can give each other a hug goodbye or whatever. Hug and a kiss goodbye. See you later. But as Carlos getting his car to move the car up, Romika jumps back out the car and run towards her. I don't think that Carlos nor Holly realized that that's what Romika was going to do that day. I don't think that they thought about that. So if the situation is calm, if he was able to calm both of them down and get Romika calm and in the car, right? Why was she down 911, or why would she sit in her car at that moment when she thinking the situation is cool? And I'm going to tell you something. Let me put this back up for a second. Now, for trial, I know this is going to be weak. Let me show you what's going to be weak. Now, I don't know if this is going to be weak for detention. I'm going to be straight up with you. Detention is on a whole different ball game. Hold on a second. Okay. Let me show you what's going to be weak for the trial. Hold on. I'm going to tell you in a minute. Let me get to it. Hold on. I know this is going to be weak in the trial. I'm not even an attorney, and I can eat this up. Let me see. And I know that the prosecutor knows this too. Let's go back up. Where is it at? Hold on. Give me a second. Where the freak is it? Hold on, y'all. Let me go back to the... Okay, so... I could tell you, but I want to show you. I could tell you, but I want to show you. Okay, right here. So, right here, it says, so, we talk about who's the aggressor, right? When a situation is calm, which right here, defendant got in her car, right? So that's what you call disengagement, all right? When the defendant got in her, when the victim got in her car, and then the defendant approached the victim car and threatened her, right? That's what it says. Threatened her. And at which point the victim got out of her car, right? She got out of her car. So already her driving up made her the aggressor, Romika. But then when the situation comes, and it doesn't matter if someone threatens you or not, is provoke you or not, right? Just because somebody say, yeah, bitch, get out, fight me, because that's what the lady said. Get out, fight me, get out, or whatever, right? When Romika or whoever, like, but in this case, Romika, when she decided to get back out of the car, she became the aggressor again. She re-engaged. So it says she got out of the car. However, the state tries to save it by saying the witness approached the victim from behind and put her in the chokehold with his right arm, right? That's what it's trying to say. However, and then it doesn't say he tried to restrain her, because he just says she approached her from behind. But why would she need to be approached from behind? Where was she headed when she got out of the car, right? So the defendant approached the victim, appeared to be, and then right here. So this is why, okay, so you remember I just said that that's going to hurt. So this is where the state tries to save it, right? Saying that Carlos put her in the chokehold and began to strike her. And then Holly approached the victim and appeared to be trying to provoke her again. So this is where the state tries to save the re-engagement. Because up here, this re-engagement showed Romika as the victim. So the state tried to turn around and flip it back and say Carlos held her in a chokehold while striking her with his on the other hand, and Holly approached Romika, appeared to be trying to provoke her again. However, the women were only arguing and did not engage in a physical fight. The victim, who was still standing unarmed, had her hands flailing in the air and was trying to break free from the witness. Defendant threatened to shoot, blah, 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 when they got her weapon. Then it says, once the victim was free, let's get to that part. Once the victim was free. Once Romika was free. So the state is really trying to paint a pretty picture, but you have to understand that's their job. Even if it, a little fabrication here and there, you know what I'm saying? It's their job. However, they saying once Romika got herself free from Carlos and stepped away from Holly. So, which this is actually will eat up in the witness's claim, because the witness already claimed that Holly was standing on the sidewalk when she retrieved her weapon, is what she tried to say. But right here it says, once the victim freed herself from Carlos' grasp and stepped away from Holly, then Holly pointed her handgun at Romika, walked toward her, and fired multiple times. Okay. Wait a minute. Where did I just put that? Okay, maybe I lost it somewhere. I don't know where is that. Okay, right here. Fired multiple times and with pauses between each shot. Okay. So, however, what's going to hurt the state is that, well, for one, a lot of things are going to hurt the state, but let's talk about it for a second. Some of the things that's going to hurt the state is the physical evidence does not match with this, okay? The physical evidence. How in the world did she walk up on Romika and fire, but Romika's body ended by Holly's car? That's one thing. And then two, witness 3 is giving this account. So how in the hell did witness 3 see all of this when she's on camera right after the shots was fired? The pod camera spotted her behind a building next to the train station. You just can't see all that. You can't see everything that you said you saw. You just can't. It's impossible. So, Ari's going to have to definitely argue those, bring her proof and whatnot. But again, so this is based off of witness number 3. But physical evidence, the medical evidence, going to prove different. It's going to prove that her body was found right by Holly's car. So I find that strange that Holly approached her, but Ramika was by her car. Because if Ramika took steps away from Holly, then she wouldn't have been by Holly's car. She just wouldn't. Her body would not have landed by Holly's car. It just would not. Like, you know, we got to just be smart about this. Like, I understand people, oh, justice for Ramika, justice for Ramika. Got it, right? However, we got to be smart. The evidence, and let me put this picture up. And I don't want to show the gross one, so let me just be careful which one I pull up. Give me a second. Let's go over this. We're not going to spend a lot of time on it, but I do want to just bring it up for GP right now. Hold on. For GP, let's get this. Yeah, I got too many folders. Come on. Where's my Holly files? It's coming, y'all. Let me just put it in here, Holly. Wait, oh, here you go. Okay. So, I'm not going to show that picture because that one is... And you know, I'm shocked that they said that she parked in front of Holly's car like that. What? How is that parked in front of Holly's car? All right, let's put this picture up. It's blurred out. So for those that, you know, want to say, oh, you showed that body, just shut up. Just shut up. It's blurred out. Just shut up. Just shut the hell up. Seriously. Y'all be doing too damn much. All right, so this is the crime scene. So now the thing says her car is parked in front of Holly's car. Let's blow this up a little bit because does that look like parked in front of to you? I mean, y'all know I ain't got the best glasses. I mean, I ain't got the best eyes, right? But does that look like that white car is parked in front of Holly's car to you? Holly's car. Now, Carlos is standing right by Holly's car, and Ramika's body is right there by Holly's car. This is where I say medical evidence, physical and medical evidence is going to say a different story, right? So one, the damn photo clearly shows that that is not in front of Holly's car. I don't know what the state was thinking about when there is evidence. I mean, unless my eyes are failing me, y'all. I do wear glasses, but unless my eyes are failing me, she said, have you seen the aerial view though? The aerial view of aftermath? I seen the aerial view of the aftermath. Yeah. But even the area view, like, okay, so are you trying to tell me that's in front of the car? Yeah, okay. So anyway, but look at the body. Where is the body? The body is right by Holly's car. So how do you explain somebody body right beside a car, but then you want to say she took steps away from Holly? If she took steps away from Holly, then how was she able to be right by that car? It says, I had to come out of the bushes. It's parked next to her car, but there is room to get out though, respectfully, and the area view does show there's room. The area view only shows, I'm gonna pull the area view up because I want to explain this to you guys. A lot of people do not understand this. This information was given out on another blogger's panel, and they explained the information incorrectly. I'm just going to be honest with you guys. They explained the information incorrectly. I'm gonna explain the area view correctly to you guys. Okay, give me a second. I'm up here spelling her name Jolly and not Holly. All right, let me get this area view. All right, here's the area view. The area view, let me take you through there, take you through there. Let me take you through there, take you through there. The area view is after the shooting. How do we know that? Let's go to some arrows. This is after the shooting. This is after Carlos had already moved his car up. This is Carlos' car. Let's put this as a different color. Carlos blue. This is Carlos' car right here. Okay. Now, this is, let's do this yellow. Let's do this pink. This is Romika's car. As you can see, I can't move that one right there because I had already put that there previously. But this is Holly's car right here where this arrow is at. This is Holly's car. Now I'm going to do a white one to show you. Actually, I'm going to do the popo. No, black ain't going to show them. Let's do orange for the popo. This is one of the popo cars right here. This is one of the popo cars right here. And this is what I call a paddy wagon right here. This shows you that this was after the shooting, okay? This is after the shooting, not before. Carlos moved his vehicle up. Even in the camera footage that Attorney Ari explained in her answer, her response, she says on video, Romika's car was closer to Carlos' car, which means Carlos' car was more back here. Carlos' car, before he moved it up, Carlos is blue. Let's change this joker back. Let's change this one blue right here. Carlos' car, before he moved it up, was back here. He moved it up. So this is after the shooting, okay? So with that being said, this is a photo after the shooting. How do I know? Cop car, cop car, cop car. So this is an aerial photo after the shooting. Carlos moved his vehicle up. Even in the paperwork, it says that she drove up and parked behind Carlos's car. Now, let me just say this to you. For those that don't believe it and say, no, we don't believe Carlos moved his car. Then I'm going to ask you this. Who did she come see? Because if she came to see her baby daddy, then why she parked by Holly's car? So we got to be careful when we try to make an assumption, right? Because if we make the assumption, let's move this out the way. Let's move the one I just put in there. So if we do the assumption and say that the other blogger that trying to say that this is the real deal Holyfield and that she was not blocked in, then we have to ask ourselves, did she really come see Carlos or did she really come to see Holly? Because why was she parked that far back from Carlos's car? Do you understand where I'm going? So we got to be careful with wanting to believe things just so it can fit our narrative, because then there's going to be another narrative there. Okay? So this is Carlos's vehicle. This right here is Holly's vehicle. Right here. That's Holly. So if this is Romika, why would Romika park by Holly and not up here by her baby daddy? So again, Carlos's car was a little further back before he moved it. He moved it up, and as he was moving his car up, Romika got out of her passenger her driver's door and ran around, and she ended up here. She ended up here. So the headlock story, you guys, unfortunately, is not true. It's not true. Okay? Well, let me just say it like this. Not at the moments of the shots. Now, you know, he said that he didn't put her in a headlock at all. However, you know, let me just say that. He said, Carlos said he did not put her in a headlock. Okay? He did not put her in a headlock. So, and they say, oh, she slipped away, or Romika backed away from Holly. And they also said when Holly retrieved the gun, Holly was standing on the sidewalk. Holly was standing on the sidewalk. So then how did Romika's body end up right here by Holly's car? That's because she advanced on Holly. She advanced on Holly. We got to be realistic when we're looking at evidence. We can listen to what people say all day long, but what does the evidence say? The evidence shows where her body is laying is because she approached Holly's vehicle. Where she dropped is where she ran. So again, we got to be careful. Oh, no, he didn't move his car. His car was always there. Okay, then that means that Romika came to visit Holly. Boom. Now what? She came to visit Holly. Because ain't no way she gonna park her car right here and not up here by her baby daddy. So again, and somebody said, zoom it in. How much zoom in do you want? How much zoom in do you want? So again, we know that attorneys can make mistakes. For one, the attorney put in the paperwork that I just showed you that it said Romika parked in front of Holly. How? How did Romika park in front of Holly? Does that look like in front of to you? And then we look at this photo. And her car is right beside Holly's. It's literally right beside Holly. Her car is right beside Holly. Like, I mean, Romika car, Holly car. That's Holly right there. Romika car, Holly car. So with that being said, somebody's asking for a mod. Do I have somebody being disrespectful? Who's being disrespectful? Just give me the name. Who's being disrespectful? I don't think you're listening to yourself. He moved his car is one thing. Why tamper with evidence? Because he walked her the way to fit their plan. I don't think you're listening to yourself. He moved his car is one thing. Why tamper with evidence? Because he walked her the way to fit their plan. I don't understand what you're saying. I don't think you're listening to what you're saying yourself. Because if you read that out loud before you hit send, then you know that's some old Ebonics type shit you got going on. So I'm going to need you to either rewrite that or go color, one or the other. All right. So I don't think that you read what you said unless you just a 5th grade reader. They moved her. They both had red stuff on their hands and clothes. If that's the case, it would have been seen on camera. The pod camera turned to that direction after the shots. Everything after the shots they saw. So if they moved her, it would be on camera. Okay. Again, the pod camera, they have everything on the pod camera after the shots rang. Once the camera adjusted to that area, they saw everything. So if they moved her, then it would be blood smears on the ground, and it will also be on the camera. So obviously, if the prosecutor had that, they would definitely show it. So that doesn't make any sense, September Virgo. Who is the Queen Troll? Is that her name, Queen Troll? She said they never heard of the pod camera. Yeah, they probably don't know what a pod camera is. She said Queen is being disrespectful. Okay, thank you, loud talkers. Let me get Queen the hell up out of here. Is it the Queen, Queen Query, the queer? Oh, let's get the queer out of here. There you go. All right, who else do I need to get out? All right, so okay, why did Carlos ever have to move his car so it looked like she parked by Holly? Huh? Why did Carlos ever have to move his car so it looks like she parked by Holly? No, that's not why he moved his car. He moved his car so Holly could leave. He moved his car to open up because Romika was already there screaming, I ain't going nowhere. That bitch gotta move. That bitch gotta go. I ain't going no fucking where. I ain't leaving until she leaves. Okay. So when you got somebody out there being that belligerent, you just say, okay. Let me move my car up so she can move. Let me move my car up so she can move. So he moved his car up so she can move. Okay. He moved his car up so that Holly could move. So Holly could drive away. But she wanted to kiss her man goodbye. She do live an hour away. She wanted to be able to hug and kiss him goodbye or whatever. And that's why he had to move his car up. It's not even a point. I thought you said his car wasn't moved until after the shooting. No. I said this aerial photo. Did I say that? If I did, I stand corrected. No. He did not. No. The aerial photo wasn't taken until after the shooting. So if I said that he moved his car after the shooting, then I'm wrong. Okay. I misspoke. What I meant to say was the aerial photo was not taken until after the shooting. Okay. He moved his car up before the aerial photo. He moved his car up before the shooting, and he moved his car up before the aerial photo. Okay. So yeah, if I said it the other way, I misspoke. If they moved the body, the state would have said that. Exactly. The state would have already put that in there. The state never said that the body was moved. And the reason why the state never said that, because the state would have to prove that. Okay. So, and that's easily to prove. I would love for them to show some type of proof that the body was moved. You would have blood. First of all, you have to understand this. I'm going to get vulgar. It's about to get nasty. I hope I don't offend anybody, but I just want to be real with y'all for a minute. Can I do that? Can I be real with y'all for a moment? I believe that there's mostly women in here. Okay. Blood gets every fucking where. Okay. Now, I'm going to get a little vulgar because I know every woman in here at one point of their life has had a cycle. Okay. Had a cycle, right? So we all know that blood can easily get every damn where if you don't get control of it. If they would have moved that body, blood will be everywhere. If you ever ran out of toilet paper at a time you needed it the most during your monthly, and you had to get up and get some toilet paper out your cabinet, baby, you done left a mess, okay? Blood gets everywhere. Quickly, too. So if after already being shot 2 times, both fatal shots, one to the femur, where blood is gushing, a lot of it gushing out. If her body was shot twice and she's gushing blood, man, blood will be everywhere. It will be a trail. It will be splatters, trickles, trails all over the place. So the body was not moved, okay? It was not moved. There's no evidence of the body being moved. Okay. She said the state not claiming the body was moved, nor are they claiming Holly shot from the sidewalk. Well, they can't go with the narrative of Holly shot from the sidewalk. They can't go from that narrative because then they got to explain why was Holly body drenched in blood. Well, it was drenched in blood because it was a closer encounter than what they want people to believe. It was very much a closer encounter between Holly and Romika when the shots took place. Looks like you guys are communicating with each other down there. Why do they say it was a car in front of Meeks and she wasn't able to move? It wasn't that she wasn't able to move. She didn't want to move. She wasn't going nowhere. Meeks was being very stubborn. Despite that being his girlfriend, she wanted the control and she wasn't going nowhere. She wasn't going nowhere. She was turning up. She was on demon time, pretty much. So it wasn't that she couldn't have moved. She could have moved, but she wasn't going to move. She could have backed her damn car up and she could have got out of Dodge, but she wasn't going nowhere, pretty much. She wasn't going nowhere. That's why we know that she wasn't standing there with her arms folded while Holly was popping off, because she would have whooped Holly's ass. She would have snatched Holly so fucking fast, okay? We're talking about a woman that told her boyfriend that's 6 foot tall, 6'4", say something, I'm gonna cut you in your fucking face. Okay, so we know she wasn't standing there with her arms just folded, letting Holly pop off at her. Okay, we know that that's just not true. Okay. I have a question about Romika didn't have any gunpowder on her. If she was close to Holly, why Holly fired the weapon, which tell me she was not standing close to Holly? Well, you need to look at that again, because that does not mean that she was not standing close to Holly. Gunpowder on you is mainly when you have the weapon pressed against their skin. And it didn't say she didn't have gunpowder. It said she didn't have soot on her. Okay. The gunpowder stuff, and I don't even know if that's come back yet. Has ballistic came back? I thought they said that wasn't coming back until May or June. So she didn't have soot on her. Okay. And that's only because it wasn't pressed against her skin. But that does not mean that she was not that close to her. She had to be close. She had blood all over her. She got Romika's DNA all over her. So she had to be close to her. She said, but Meeks didn't want the baby mama anymore. What do you mean, but Meeks didn't want the baby mama anymore? You mean the baby daddy? You mean Meeks didn't want Carlos? Is that what you're saying? Clarify yourself before I answer that. I feel Romika wanted to get the last laugh and to say she made Holly leave so she can joke about it, but it ended bad for her. No, I believe she wanted to beat her ass. I believe she wanted to bash her face in. She said blood was dripping off of Holly's hand when she was handcuffed. They both had a lot of blood on them. I don't know. It's just weird in my opinion. They had a lot of blood on them. Well, we already know why Carlos had a lot of blood on him, but the reason why she had a lot of blood on her, because they was very much close to each other when she fired those shots. So all 18 of the witnesses lying on Holly. There's only 5 witnesses. I think you need to go back to school and count it again. There's only 5 witnesses. She said the case is sad as fuck. Everybody lost. Holly is cooked too. Poor ladies. The case is sad as fuck, but we don't know if she's cooked until after the trial. She said, what do the medical examiners say? A medical examiner say about what? The autopsy report won't come back until June. We won't find out that until June. But it does show that the bullet went in front to back. So that takes away them trying to say she retreated. So the state was very careful not to say she retreated, because then the bullet would have been her shoulder, her arm, like the side of it, or something like that. It would not have been front to back. So they were very much facing each other when the shots were fired. She says stifling is basically a burn from the flash of the gun that was present. I think they said, well, there was no soot. And from what my research tells me, that just means that the gun was not pressed against her skin. Because if the gun was pressed against her skin, that's more executional style. So the fact that there was no soot, that's actually better for the defense than it is the prosecution. If Holly did not have a gun that day, we would have buried Holly. Ooh. I heard today from Meek's supporter that the time Meeks pulled up, she was on the phone with her boyfriend at the time. I just wish that he would testify and give them what he knows. Yeah, no, I never heard that, and I really don't believe anything that they say, because they lie a whole lot. So I don't even listen to them. We will see how weak or strong the case is after June or July. Yeah, that's true. When those autopsy reports come back, we will definitely see how strong this case is. There are 18 witnesses. All of them are not testifying. Then that makes them not witnesses then. They're not witnesses. If they're not testifying, they're not witnesses. I thought you would know that. They are saying that Holly got the pow out the car. They have to prove that. They would have to prove that. Witness number 3 was nowhere around to be able to witness whether or not she got the weapon out of the car or not. She was seen on camera somewhere else. So that's going to be presented in court. She was not at the crime scene until after the shooting took place. And you have to understand, if they were not in the proffer, then they're not being called to testify. So either their statements wasn't credible, or that they just said that they don't want to make a statement. If I saw something, I witnessed it. I thought to you would know that. Well, unless you gave a statement to the authorities, I mean, you could say you witnessed anything, but unless you gave a statement to the authorities, then you're not a witness. I mean, I thought you knew that. I don't have to make a statement to witness. Well, if you don't make a statement, how's anybody going to know what you said? Yeah, okay. They claim it's more than 5 witnesses. Yep, and they also claim Carlos was locked up today. They also claim that Holly is not in protective custody. They also they claimed a whole lot of stuff. Literally blood on their hands. Vengeance is mine, said the Lord. Yep, but self-defense is not murder, said the Lord. Let me read a little bit more. They said that Carlos said that he moved Romika's body east to move her out of the traffic. I believe it was the 2nd or 3rd court hearing. Not true. I got all those transcripts. That was not said. Who said that was the damn Tatia, the damn Fox News lady, said that it was moved east or west. She said that shit. The state not claiming the body was moved. No, they did not say the body was moved. She said no witnesses matter. Why Romika's dead at Holly's car? That's something nobody can explain. Exactly. And they don't want to even explain it. They don't want to explain it. Well, actually, they want to try to say Carlos moved her body over there. Okay, well, prove that. If the boyfriend was on the phone, he's not talking because he's embarrassed as a boyfriend. Probably so. I see a lot of bitches as Tamika supporters in here. Go to Key's page and let Amore do her thing over here. Take your fucking ass out my chat and don't you ever promote another motherfucking goddamn content creator in my chat, you bitch. Don't you ever bring your ass over here with that shit again. You dumb fuck. You banned forever. She was reading from the transcripts. No, she wasn't, because I read those same transcripts that she read. It did not say that. No, he probably turned her to the side. He did. I got the video. He turned her to the side. That's about as much movement as he did. He turned her to the side so she wouldn't choke on her blood, but evidence shows she was not moved. I got the whole video. I know exactly what he did. I don't want to show the video because they say it's disrespectful, but I have the whole video. He did not move her. He moved her from her back to her side. That's the movement that they were referring to. But that east to west and out of the traffic, matter of fact, it was out of the traffic was something that Tia made up. The case shouldn't even be a thing. She had a TPO, and Ramika still pulled up. She got what she was looking for. Ooh, Rainy, that's a little. She said, Amore, are you saying the reason why Holly had the blood on her on that drawstring is because Ramika was standing close to her when she fired her weapon? I believe that they were standing close and Ramika's DNA got on her because they was in a physical tussle. Sometimes the state be holding back the most important information until it's needed. Not so. You can't do that. Not from the defense. You can hold it back from us, but you cannot hold it back from the defense. That's not legally allowed. When you have stuff, you have to give it to the defense. Just like if the defense have stuff, they have to give it to you. I mean, excuse me, they got to give it to the state. You cannot withhold evidence like that. She said the witnesses said Carlos said Holly has a gun, but then say she went to the car and got the gun. So how does state say she started firing when she broke away from Carlos? How did she have the time to get it? So that's witness 3 has told like 3 different stories. And that's why I'm glad Ari has her on videotape that at the time the shots fired, she was nowhere near the scene. She was nowhere near the scene. And I think I've showed y'all plenty of times where she's at. Just in case some people are in here that does not know, let me pull it up where she was. Let me show you exactly where she was at the time of the shots. And you tell me, did she see and hear all the stuff that she claims she saw and heard? Now, we've been over this several times over here. Now, this is per the defense. This is per the defense. Per the defense. Now, they're going to have to prove it, but per the defense, the incident happened down here, past all the way down this area, right? That's where the incident happened. She was spotted here at the time the shots was fired. She ran into this building to tell them that there has been a shots fired. So she was spotted here by the pod camera. Here. Boom, boom, boom. Here, y'all. Here. Right? Do y'all see this arrow? Do y'all see it? She was spotted here, but the shots were all the way down here. Let's go down there where the incident took place. So the incident took place down here. So I would love for her to be able to explain to Ari or the courts, period. Oh, shit. Come on, Amor. I always do that. Oh, let's go back. Let's go back. Let's go back. I done messed up the damn arrow. But anyway, I would love to her explain how the hell she can see and hear all the pushing and shoving and the provoking and the threatening and going in the car, getting a gun and doing all of that when her ass is all the way back here when the shots was fired. There were other people out there that was closer to her that said that they didn't hear shit, that they could not hear. All right. So again, she was standing behind this damn wall. She came out from behind this wall, this alleyway right here, right after the shots was fired. Now, mind you, she also had her baby stroller with her. Plus, Ari put in a motion for the state to turn over all evidence from September to January. I'm also positive she will request it again. I want to say they have the evidence now. They have exchanged evidence. I'm sure there's going to be more evidence that they're going to have to exchange, but for right now, they have the evidence that they're using thus far. The things that they're using in their motions, they have. Why is witness number 3 saying Holly shot from the sidewalk? I think she's saying that she shot from the sidewalk. Now they changing it though. They say that she shot from the sidewalk and advanced toward her. I think that she's saying that witness 3 saying she shot from the sidewalk and witness 5 saying that she shot from behind the car. But I think that they're saying that because they wasn't thinking about the blood transfer. And I actually, to be honest with you, I don't think not one of those witnesses saw the shooting. My hearts of hearts tell me not one person saw this shooting. I think they're lying, if you ask me. I think witness number 3 is lying, and I think witness number 5 is lying. I think both of them are non-credible witnesses. Now, if I have to eat crow, I'll eat crow, but for right now, I think they're lying. She says, if that's the case, there shouldn't be that much blood on them, especially Holly. I don't believe they were that close to one another. Well, then how do you explain the blood? If they wasn't that close to one another, how do you explain the blood on Holly? How do you explain the blood on Holly? I don't think Ari can prove that since there's no video evidence of the actual crime. Maybe she ran after the first shot. But guess what, though, September, Virgo? Ari doesn't have to prove that. You do know that, right? Ari does not have to prove that she shot from the sidewalk, she shot from this place. She doesn't have to prove any of that. The defendant is innocent, and to proving guilty, the state has to prove everything that they're claiming. Holly does not have to prove that. Ari does not have to prove that. So let's clear that up. With the many stories that came from the witness 3, I don't see her being credible. Neither do I, because she said a lot of stories. And she changed the story from in front of the police cam to the next day at the police station to the blogger on YouTube. She gave out all different stories. So no, I don't think she's credible at all. That lady said she saw blood gushing from her mouth when she was shot as she fell to the ground. How the hell she see blood gushing and she was all the way back here? Let's do the math. Let's do the math. She said, unfortunately, the judge already said Carlos is not credible. That's not what he said. He said that he was not an independent. I mean, he said that he was, what words? I got the transcripts of his, and let me just pull it up. Let's pull up exactly what the judge said, because the judge didn't say what you just said. And that was for detention purposes only. Okay. I got it. Hold on. For detention and trial, that's two different things. And I think that's where a lot of people are missing it. Detention and trial is two different things. Oh, that's the motion. Okay, that's not it. Let me get the proffer. Nope, that's not it either. Nope, that's not it. Nope, that's the grand jury. Nope, that's not it. I would have to look for it, you guys. I got so many. I got over 100 documents. I would have to look for it. She said the judge didn't say Carlos is incredible. Reread what they quoted today. They said he could have bias. Yeah, they said he could have bias, and he was basically a standalone witness. Basically, that his testimony is quite different than all the others, and that he has interest, bias, and interest to sway the story a certain way. Yeah, said that he has reasons to be biased. He did not say he's not credible. She says, no, I'm talking about witness number 3 probably ran after hearing the shots. Even if she was ran after hearing the shots, you got to understand, she got a baby carriage with her, right? And if she ran, it would show her running. Actually, on camera, it showed her she only got this far when the shots rang. She never got this far until after the shots rang. They follow her on camera. She's on camera. The detective follow her on camera from the time she got off the bus. Her every move is on video. Her every move from the time she got off over here on this side of the street, walked all the way down here, crossed over down here, walking all the way back. The furthest that she got right here, the furthest that she got was right here. And then she ran in here, and then she ended up going down here, and she did not cross the street to go over toward the crime scene until after a cop showed up. A cop pulled up. That's when she's seen crossing the street here, crossing here, and going here. She's on video the entire time. So, yeah. That's what Ari said. Ari said she is on video. Actually, she's on video from the time that she was in Chinatown on the CTA bus. They tracked her from Chinatown on the CTA bus all the way until she got off the bus, crossed the street, came back down. She is on camera the entire time. They got her on camera. They got her whereabouts the entire time. She said that's reasonable for a judge to say Carlos could be biased. That is reasonable. I find that's reasonable, but non-credible, no. But he could be biased. Yes, I think that's very reasonable. Most people didn't see the video when no one was there before the police came. I got the video, but I can't show it. I tried to show it to this one blogger, and then she went on her panel and said that I show her the most disgusting thing ever. So I'm not going to show it no more. But I have the video, and it shows there's no witnesses around. I have that video. That's why I stand a little bit firmer than most people in my stance, because I have that video. There were no witnesses there. There were no witnesses. Well, let me take that back when I say there was no witnesses there. There was a witness walking up when Carlos was on the phone with 911. There was a black man walking up, and there was other witnesses coming, approaching, but witness number 3 wasn't there. Can you play the audio? I can play the audio, but I just think the audio without seeing the video, I just think that it would I think that you need to see the video with it. You know what I'm saying? I think you need to see the video just to see just how. Let me see if I can show you a picture. Hold on. I think I've showed you guys a picture before. Let me see if I can grab it. Yeah, the audio I think is probably without seeing the. Okay, so here's the picture right here. This guy was walking up, right? And he's not even, he was talked to and said he didn't hear anything. So he was even closer than witness number 3, and he said he didn't hear anything. But understand, this is after the shots. But before the shots, no one was there but Holly, Romika, and Carlos. But after the shots, and he's on the phone with 911, you see this witness walking up. And they saying they didn't even hear it. That's why Ari said it's people that was closer to the crime scene than witness number 3, and they didn't hear anything clearly. But all of a sudden, she all the way down by the green line and can hear threats and hear all this other shit. Yeah, okay. With headphones on her ear, with her child. Yeah, okay. Yeah, okay. Yeah, okay. Yeah, okay. Because the Mexican man said that Carlos was trying to get Ramika to leave. You mean the Hispanic man? The Hispanic man did put in a statement and withdrew his statement because he actually said, yeah, well, I lied. I wasn't there. But on the audio at the scene on different cell phones, you hear him saying, I was there, broski, I was there. Well, he's withdrew his statement because he came back and said, yeah, I lied. I wasn't there. My girlfriend told me everything. Yeah, he wasn't there. But he said on that phone that he was there. I was there. I saw it, broski. I was there. I was there. Yeah, okay. He was not there. His own words, though. She said, if it's not of the actual crime, it wouldn't be useful. If what is not of the actual crime. She said, but she stayed twisting what the documents really say. Who stayed twisting what the documents say? What did I twist, Steve? What did I twist? Tell me so I can go over it with you. Tell me, what did I twist? Please let me know. Let me know what I twist. Let me know what part and I'll go back to it. Let me know what I twist. The video is useful. It shows that witness number 3 wasn't there. The video, it definitely shows that number 3 wasn't there. She wasn't there. Her voice wasn't there. She was not there. She was not there. She was not there. She was not there. So anyway, I'm going to wait on Steve to tell me which part that I twist so I can go back over it because I don't want to twist nothing. And you see there was no moving of the body or there would have caught it on video. Exactly, they would have caught it on video. There was no moving of the body. And if it was, the state would have put that shit in the damn appeal too. Don't you think? Amor, that's irrelevant because you showed the documents as you read them. We can read for ourselves. Yeah, that's true. Some people can't, though. Some people can't comprehend. Thank you for the tip. I appreciate you. It's going to raise more questions. No audio. Yeah, that's what I thought, Nell. I was like, playing the audio without the video is going to, he said the video here. Yeah, playing the audio without the video, I think will cause people to spin out even more because you would have to see what's going on because what they're saying is like, ooh, they're talking as if like she's the most dangerous person in the world. She got a gun. Why did she do her like that? Oh my God. How could she do her like that? And stuff like that. More, I just read that one. Oh, you're welcome. So yeah, so that's it, you guys. Again, this is just the state's response. We have to wait until I do believe that Ari will be sending a response to this. And I think some of the response is going to be, well, the video is there because if I'm not mistaken, they uploaded the videos. Like they had a certain amount of days to upload the videos and the evidence, and Ari did that. She met her deadline. So I believe that the state wrote up their answer quicker or sooner than or maybe not even knowing whether or not the video footage was submitted. I don't know. I don't know. The witness three called the police before the powwow. Yes, she says she did. She says she called the police before the powwow. But the calls before the powwow states that there is a woman holding a gun and that they are fighting. Okay. But a lot of people say they wasn't fighting, but that's what one of the 911 callers say. They're fighting, and the woman, I want to say it said the woman in the green has a gun or something like that. She said, okay, I'm just trying to get more than one perspective. That's all. I'm not trying to be disrespectful. I'm just trying to hear more than one side. That's all. Yeah, no problem at all. Yeah, no problem at all. There was one other person too. I have the call log, but what I don't have on the 911 call log is I don't have the call made of the beating in the back with the car. I don't have that, but I'm not saying that it's not there because it's quite a few of them with the black thing going over it where they just kind of cross some stuff out. So I don't know what it says altogether, but I didn't see not one that says that there was beating in the back of the with the car door. I didn't see that 911 call. Yeah, redacted. She said some of the stuff is redacted. So I have one that is heavily redacted. So if that's the case, if that call is one of the ones that they redacted, then yeah, I don't know what it says. But I don't see any of them that says that they reported someone getting beat in the back with the door. It just talks about the two women fighting, and then some of them say, oh, it's road rage, is 2 men and 4 women, and it just says a whole bunch of stuff. Some of the 911 calls are all over the place. But anyway, I'm about to get off. I hope that answered some things, but basically this is just and what I'm going to do is I'm going to upload this paperwork to my members only live. So if you are lit up in green, I'm actually going to upload all the documents that I have, which is a lot. Okay. I'm going to upload it to level 2 and above members only. Okay. Level 2 and above members only. Not live, but just members only, to where you guys will be able to see it. All right. If you are a member. All right. So I'll be doing that, all the documents. Let me just put them together so I could be able to tell y'all this is this, this is this, this is this, this is this. So we can go back and refer to them. She said, make sure you watermark. Okay, let me get Candy to watermark them first. Thank you. Let me get Candy to watermark the documents first, and then I will have them uploaded. So it may not be today. Give me time. Witness 3 was the first 911 call. If she was the first 911 call, then that first 911 call says, let's pull it up. Let's pull up the first 911 call right quick, y'all. Because the first 911 call does not say that there's a man with a gun. I mean, a man in a chokehold. Hold on. 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 Let me get the call on. Hold on, I gotta get it, y'all. Hold on. Let me look it up another way. Let me look it up this way. I don't know what I would have named it. What did I name it? What's the police? Let me see. I'm trying to think of what I would have named it. What would I have named it? Let me just put 911 calls, maybe. Or maybe dispatcher. Hold on. I have it. I gotta think of what I named it. Oh no, that ain't it. No. I know I have it. I just don't know what I did with it. Oh, that's not it. I showed it on here. I just can't remember what I named it. I'll have to get it another time, y'all. I'll get it another time. But I do know that the first call came in at like 9:02, but it didn't say anything about beating the car in the back. And the first call came in at 9:02, but at 9:04, that's when the shots were supposed to be fired. Let me hold on. 9:02, the first 911, and 9:04 when the shots were supposed to be fired, but also at 9:03, I think it is, she spotted behind that building. She spotted behind that. I'll have to look at it again, y'all. I'll have it for y'all the next time I come on and talk about this. But it was. I went over it the last time I was up here. 9:02 was one thing, 9:03 was something else, and 9:04. So she didn't have enough time to be down there and then back to be spotted behind that building from the time she called, from the time the shot rang. So anyway, I'm about to get off, y'all. Appreciate you guys for stopping in. I am going to do a live later, but I'm going to take me a nap and I'm probably going to come back late. Now, I said I was going to come back late last night and I ended up not coming back, but I'm probably going to come back late because I know I'm going to wake up from a nap, but I'm about to go take a nap. This is what old people do. I normally don't come on to 7, but I'm about to go take me a nap or either go walk with my husband, one or the other. All right. So, but thank y'all so very much for the love. Thank you, love. For the super chat, Courtney Hill, I am Glenn for real, Tawana, Rita, Bonita Spears, and Nell. Thank y'all so very much. Let me read this one. So Holly was supposed to just let Ro beat her up and her baby come on. Ari, do your big one. Romika was wrong. Yeah, Romika was wrong. I do believe Romika was wrong. I'm sorry that she lost her life, but you know, none of this would have happened if Romika wouldn't have pulled up. Okay. And we have to remember that, you know. And we also have to remember, you know, wanting to fight someone for whatever the reason you want to fight them. We need to be careful with wanting to put our hands on somebody as grown adults because it will escalate. But anyway, thank y'all so very much. I love y'all. Y'all hit that thumbs up button. And I will talk to you guys later. Bye now.
Because they can't make $1 without mentioning down one of our names.
Jay! She kept talking about that family.
Hoes over there.
She kept talking about that family. 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 That family. She kept talking about that family. Talking about that family.
These motherfuckers don't be wanting to listen to them. Because they can't make $1 without mentioning down one of our